All right, folks, I'm attorney Roger P. Fuller, and I want to talk to you about things that are not appropriate. It's been a long day, had an evidentiary hearing / trial, opening, closing, direct cross-examination. So I had an opposing counsel that right in the opening started bringing up topics, other cases that are irrelevant. They're not coming into evidence. And he's trying to, I don't know, get in information to the fact finder that he wouldn't normally be able to get in. And of course, what the lawyers say is not testimony, right? But it seeps in. At first, I kind of let it go, thinking, and then, okay, objection. The judge sustained it. Then we get to direct examination. And this attorney is just, look, they're asking questions, and I get it, but it's not in a format. You know, what happened next? And what were you wearing that day? Or where did you go after that incident? Or like, it was just, hey, so tell me what happened on January 5th, 2023. And the person's giving testimony, and it's like, I don't know, like the life story. Of course, I object. She has a right to answer, no problem. But going off and expounding on things that were not even questioned, I got a problem with, and so did the judge. Well, I probably objected like 10 times. Judge, like, moved to strike the answer, just giving a narrative and like telling some story. And we don't even know when the story was. I mean, there's no clarification from counsel about, okay, when did that event happen? Like nothing. So made a bunch of objections, and I get to cross-examine the witnesses. I start with prior testimony, right? What they've said about these topics that she just spoke about in direct. And again, you get what we call the runaway witness that wants to just tell you like, well, I was wearing blue, but I was devastated wearing blue. So I had a few motions to strike, you know, as unresponsive, and they were sustained. And then I did some where I objected, and the judge said, you know, based on what? And I was like, narrative, hearsay, relevance. And she goes, I'm going to sustain it to narrative, but there's an argument that it's relative. But anyway, it was sustained. I don't think I've ever had this happen before, but sometimes witnesses want to banter. I don't want to banter. My job is to treat everyone with respect, kindness. You just do it succinctly, right? When you do surgery, it has to be precision. So I was asking, I need you to really focus on the question. I'm saying this with all due respect. Listen to my question. You're not answering my question. Yes or no? And of course, they're allowed to say yes or no, and then if they want to explain further, they can. I get it. So at one point, the witness goes, well, with all due respect, counselor, I'd like to ask you this question. And before she could even, get out the question, I said, ma'am, I'm not here to answer your questions. You're here to answer my questions. So I'm not going to be answering any of your questions. Here's my question. Please answer it. Stern, not rude. Stern, that's my job, right? I am a player in the game. It's me against the other lawyer. The judge is the referee. And the other people are, they're parts of the case, but it's not their show. And since that witness is saying something opposite of what my client is saying, they're not the star of the show. And I say that with respect. And again, I wasn't rude. I was very courteous to the person. But you have to put people in their place in certain situations. Everything in life, right? You got to go, hey, that's not how we do things. Then closing. And I'm not saying where I was. I'm just saying opposing counsel. You guys know what I did, right? So opposing counsel starts this closing, again, all over the place. Counsel goes off on this narrative, which totally misidentifies the evidence that was brought into the case. Objection.
I can't not object when you phrase questions so improperly.
And the judge said, wait, counsel, stop speaking. What's your objection, Mr. Fuller? Judge, I don't think I've ever objected to a closing in my life, but I got to object. This is highly, highly inappropriate. There is no room. There is no attorney that should be using this vocabulary, these words, this argument in a court of law. Sustained. Counselor, move on. I objected again in closing.
My children.
The judge was kind of going, well, sir, you might want to rephrase that, and sustaining my objection. And then, the other counsel just got frustrated, said, I'll just withdraw what I'm saying. As soon as they do that, folks, you know what that means, right? You know that the victory is there. You don't need the judge to tell you that the victory is there. When you get opposing counsel to start withdrawing questions and withdrawing parts of their closing, you've gotten under the skin.
It rubs the lotion on its skin. It does this whenever it's told.
You know that it's gonna be a good day. I got back in my car and client sent me an email and just says, hey man, I just want to let you know, I don't think I could ever express to you how much this means to me. You know, you came, you conquered, and then he wrote, you are the Mike Tyson of the 80s in the law.
Makes him feel like a gladiator.
It's like a little pat on the back, right? It's, you know, who knows, right? You know, people don't sit and watch trials. I wish they did. You know, it's a good learning experience. Anyway, long story short, we crushed, the client's happy, and we move on to the next case tomorrow. I'm attorney Roger P. Foley. Be safe. Have a blessed week.